for delivery of judgment, item 21 to 25.
Accordingly, for the reasons recorded herein above, the judgment dated 29/8/2018 and order of sentence dated 15/9/2018 passed by the learned special judge NIA Assam, Guwahati Special NIA case number 5 of 2015 stands set aside and the appellants are acquitted of the charges leveled against them. The accused are directed to be set at liberty forthwith unless detained in any other case. The reference also. Reference also. That's dismissed. नहीं.
Item 26 to 30 for judgment.
For the reasons, for the aforesaid reasons, we are unable to sustain the action of the state government and the judgment of the learned single judge. The appeals are accordingly allowed. The common judgment and order dated 29/9/2023 passed by the learned single judge is interfered with. The termination order issued against the appellants are quashed. The appellants shall be reinstated in service with continuity of service for all notional purposes, including seniority and pensionary benefit as per rules. However, balancing the equities and bearing in mind the public exchequer, the appellants shall not be entitled to back wages for the interregnum period. The respondent shall give effect to this judgment within a period of 8 weeks from the date of receipt of a certified copy of the judgment. There shall be no order as to cost.
I agree.
Deeply obliged, Your Lordship.
We are grateful, my lord.
Adjournment request, if any, from item number 1 to 6.
Yes.
From item number 7 to 18, adjournment request. 7 to 20.
My lord, I have taken the consent from the senior counsel Bididas in item number 15, my lord. We need, my lord, some time to file an affidavit. This is the PL, my lord. This is about the
Sericulture-
fixing of the
sericulture
sericulture farm. My lord, we need some time. We are dismantling it, my lord. So I will file an affidavit to
You are
the,
moving to which place?
my lord, we will just auction it, my lord. That whatever, and maybe when government gives us some land again, we'll go for farming.
This
There are
sericulture thing had been running for several years, I believe.
60 plus years.
But then ancient monuments, the other acts have supervened.
Only because of that. Otherwise, my lord, we are protecting this for the last 6 decades. We are the one who protected this entire
No, I
land.
mean, agreed. When we were deciding this, it occurred to us that because of your presence, the monument was protected.
Exactly, my lord.
But then we can't tinker with the law. Anyway, let's,
My lord.
as prayed for on behalf of the respondent. Whom? Respondent number?
Respondent number 3, my lord.
As prayed for on behalf of respondent number 3, after having obtained the consent of the council for the petitioner, the matter is adjourned to give or take March. That time the law. They're giving you March. By that time you can finish off, or you can impress upon the government to release you or whatever, but they can't, the government can't do it.
No, my lord. We have taken a call, my lord.
The
We are doing
government
it,
can give you another land somewhere which is not within the monument area,
my lord.
and then you can continue with it.
My,
I think you have machinery and all, everything.
yes, my
And
lord.
how many workers?
My lord, mostly this, only the farmers was involved there, my lord.
Okay.
We used to, the local farmers, they were using this land and we just giving them logistic support. Lot of employment was there, my lord. It was a very, very big farm and only the local farmers were involved there. We gave logistics
But
to them.
there was no way out. No?
Six decade. A huge farm it was. Means, my lord, the thing is that we have to chop off all the trees and all, then those
What to
things.
do? I mean, that is the whole difficulty. The other central acts are against this. Now it is within that area. We
Exactly,
we
my lord.
tried to.
We
tried
ever,
to-
even
we
never
tried-
knew it, my lord.
we tried to delay it, but then there was specific report that you are inside that monument.
Exactly, my lord. No doubt.
So the monument cannot be rebuilt, but your farm can be rebuilt. That is the logic that satisfies us. Normally, while destabilizing any system, we think 5 times over.
My lord.
Anyway, all.
My lord. Deep
We
level.
are giving you March.
My lord.
Sometimes.
20 March.
Huh?
20. 28 March.
Lordship, in item number 20, we have circulated an adjournment slip yesterday, Lordship. Sometime may be granted, 2 weeks, Lordship.
All right.
20. And it may kindly be fixed, Lordship. Lordship.
23rd March.
23rd March. Obliged, Lordship.
May I please, your lordship. My lord, this is the matter regarding casual workers whose service was regularized.
Just a minute. Item number 19 and 20 both should mention.
Only 20.
Only 20. Who appears
Item
in
19.
number 19?
Please mention.
Why don't you say so? You have just circulated the slip.
May I
Unless you
plead, your
make a
lordship?
motion.
With the consent of the
All right.
order
Yes.
side, I beg to
Yes.
mention item number 19 for adjournment.
All right. It's done. Yes.
My lord,
25th March.
casual workers whose services have been regularized and they sought certain areas, salaries, etc. For that period, but the state has denied. Then we filed writ petition, honorable
What do you want?
single just, it may kindly be listed on 3/2/26. Because state has filed the appeal on the ground of delay, and since last 1 year, it is delay matter is pending, and we are now more than 70 years of age.
I can't, we can't, you inform the state. Where is that statement of yours that you have informed the state that you will be mentioning for an out of turn listing? You're the respondent there.
Yeah, I am the respondent.
File an application
but-
in that writ. That you want an early hearing. Otherwise, at your instance, we can't uplist it, no? Or come jointly, we will do it.
Jointly, they would not do because they
They
have
will not do. So you file an application in the same thing. Whether you have been, you must have been impleted there
before the registry or before your lordships
before the registry.
obliged.
And then make a mention.
Obliged.
Yeah, please, Your Lordship.
Who appears, who is the officer for a state? Which department is this, Mr. Council? Which state council looks after PWD? Inform Mr. Dinar. Inform Mr. Dinar. And in case he is agreeable, you can mention it tomorrow without filing any application. Tomorrow is Monday.
I will.
We have only tried to cut short the delay. If he agrees, then we have it uplisted.
Lordships, I have a prayer for a listing of a fresh writ appeal on 3rd of March. So sorry, 3rd of February. There is an urgency because the IOCL has informed the appellants that they are going to vacate the premises in question as per the direction of the single judge's order.
So therefore, it's in compliance of the order. Where is the urgency? It shall come in its usual course.
Lordship, the
It shall
urgency,
come in the usual course.
the writ appeal may render in
It can.
practice.
There has been a direction to the IOC to remove their establishment. Are you saying that?
Yes, That,
It's
the
pursuant to
appellant-
an order of the court.
there are some
You
irregularities.
have
in the-
challenged that
We have challenged that.
and you're the owner.
No, I'm running a retail outlet on the basis of a lease.
That's all right. So you're running the retail outlet. IOC is taking away what right do you have? Were you a party in the writ petition?
We were a party, but we were not represented. The appellants were not represented in the writ petition.
And what was the ground on which this vacating, this order was passed?
That there is no valid lease agreement available.
Ah,
But there is a lease agreement which
No,
was
this
never on,
outlet center, this has to go. Anyway, we'll have it sometimes in the second week of February.
they are going to vacate it as per the direction.
That also we can't do.
Lordships may indulge me in
You are asking for a stay of the order of the land single judge. Do you
No.
have good grounds?
Lordship.
Very well, heard.
3rd of February, deeply obliged.
You ask for March?
No,
Third of February.
deeply obliged.
My lord, regarding item 14 of the today's list, my lord.
Yes.
My lord, an affidavit day before yesterday, an affidavit is filed for the material record along with my lord. This is required to be with the file, my lord, for the affidavit.
Bring it, that after. That open dumping site.
Yes, yes.
Copy. Yes. Daily list for orders, item 1 and 2.
May I please, your lordship? So this honorable court by the order dated 4/4/25 has allowed us to take Dusty. We tried to take Dusty, but we could not find the address of the local addressee there. So we made a Panchnama there. So we have filed our affidavit yesterday. That is not on record, lordship.
That is case. You have, has it been served or not?
Not, lordship. The addressee could not be found there, lordship. Accordingly, a Panchnama was made there.
Any information? Where has it gone?
No, lordship, we have asked the locals there. They have no information
Newspaper
about that.
publication also would not do. Here's the respond number.
Respondent number 1.
Despite all efforts of the appellant, the respond number 1 could not be traced. A Panchnama also has been prepared by the appellant at the designated place of stay of respond number 1. But however, the lead counsel for the appellant submits that service of notice could be directed through paper publication on deposit of requisites for issuance for publication of notice to respond number 1. What did I say? With the registry, comma, a copy of the notice shall be served upon. 2 copies of the notice shall be served upon the counsel for the appellant, who would then get it published in 2 state dailies, having good circulation in this state, having a reasonably wide circulation in the area. And after the publication, comma, copy of such publication shall be deposited with the registry within a period of 4 weeks, whereafter this case shall be listed under the appropriate heading. 2 newspapers, one in English and the other in vernacular / Assamese.
Much obliged.
18 March. next date. Item 3,
Your lordship, it has come for orders. May it come for admission, your lordship, next week. My senior has some personal difficulty. Your
I may be
lordship,
for respondent number 1, my lord, here, the reprisoner.
For seniority only, no? All right,
18.
we keep it tomorrow.
My lord, tomorrow is, my lord, I will be out
Tomorrow
today.
means Monday. You people don't understand this. When I say tomorrow, that means the next
No, my
working
lord.
day. Don't have to remind me that tomorrow is a holiday. Monday.
My
Any
lord,
difficulty?
it needs to be heard. It needs to be heard. You know, on merit. And however, there is an order by this court, my lord.
So you argue on Monday, no?
Also, your lordship, respondent 6 has not been represented, your lordship, even after service, the service of dusty, your lordship.
Let's.
No, I think that's the service they have taken. Now
He
service
has
is
not
complete.
cleared. Service is complete. He will let him not
Yes.
appear. Why do you worry?
Yes.
Why do you worry? Our responsibility is only to let him know that we are deciding this matter. He should be represented. He chooses not to, we can't help it. Ligya, as prayed for on behalf of the appellant, let this matter come up for consideration under the heading admission on
Monday.
Monday.
Item 4.
My lord.
How can you bring new grounds?
My lord,
How, whatever has to be done on this.
my lord.
He is not yet filed.
No, additional act, my lord, will give
Why
me.
did we permit you in the first instance? We recall that order of permission.
My lord,
It's
will-
not required, that's not done.
my lord, some document, I have prayed, my lord, to annex, my lord.
Then we are not passing any order facilitating such improper exercise of jurisdiction. You do it by the next day.
My lord, my lord,
We will only adjourn the matter.
my lord, my lord.
As prayed for on behalf of the applicant. Let this matter come up for consideration under the same heading on. After 2 weeks,
My lord.
Can it be little earlier, my lord, because
after 1 week,
My lord.
12 February. Item 7. Sorry. Item 5 and 6.
Lordship, otherwise the TP matter, the public prosecutor matter has come up to the lordship before the single bench, your lordship. So may I please the matter by Passover time being, your lordship.
no, they have come from Nagaland to assist us. We can't do like this. Well, say, come at 2. Come at 2.
Item 7.
Just a minute, Mr. Palgopal.
Item 5 and 6. Item 5 and 6. Is there?
And where did it come from?
Mr. Gautam is
Mr. Balgopal, why has it come for orders? It should be under admission.
There's a IA pending, your lord.
Huh?
There's a IA pending.
What is the I?
IA for stay, your lord.
You do one thing. We are posting it for admission and there we will decide the IEL.
Lord.
So comfortable on which day?
Lordship, otherwise the.
No, I'm asking Mr. Palgopal. You will be here.
Asking for that date, which date you come.
You can keep it in.
Do we place it on Monday?
Monday.
Louder, sir, louder.
Keep it on,
We have another, we don't get.
keep it on fifth if it is all right with the lordship. We have another matter also. If it's
You have
convenient,
another matter on 5th.
Yeah.
All right,
if it's convenient, your lordship.
take it.
Lordship, if I may, lordship, there's another PI by the same petitioners, your lordship, that is fixed on 20th of February.
That's separate. That has already been segregated.
5 and 6. Let these PILs be listed on 5th of February under the heading orders, under the heading admission. What stay have you asked for? What stay have you asked for in that IA?
Stay
Yeah,
of
what?
Notification, your lord.
Notification saying what?
The not being allowed to, we need ILP to enter Dimapur, your lord.
They are seeking us to your lordship, the notification, your lordship, posing ILP in Dimapur.
Dimapur.
Not answered.
We don't stay notifications, we hear them.
Lord,
Sorry, we'll hear it in admission.
lordship.
My lord, our presence may be recorded. Last time it was omitted in
inadvertently.
What is it?
Our council's names were not there last time.
The
We
names of
write
the
the
learned
names and give it,
advocates
they may be recorded.
appearing for the parties shall be reflected in the cause list henceforth.
Probably.
Item 7,
Okay.
Made resolution. My lord, I have filed
Has
this
this
writ
been
appeals
Supreme Court?
filed by.
Yes, the original matter went to Supreme Court and settled there. The order of your lordships has been upheld. The
Then-
SLP dismissed.
Then what do we? Tell him.
No, my lord, my lord, before Supreme Court, my lord, we are not party and your lordship, our point is to be decided by your lordship. Your lordship, there is a
Anyway,
point.
what happens to respond number 5?
Lord, notice has been served. There is an office note day before yesterday, my lord. Notice has been served, but he has not appeared as of.
Awaiting the, despite service of notice on respond number 5, he has not appeared. The rest, all other respondents are being represented by Mr. H.K. Das. learned advocate.
Well, there is another private respondent, my brother is appearing.
The rest, all other respondents are represented today. Awaiting the appearance of respond number 5 in this matter, let this case be listed on, we'll finish it on 13th of February,
My lord,
Obligation.
under the appropriate heading
highly obliged.
of admission.
item 8,
Lord, successful bidder approached before this honorable court, and this honorable court in page 14 directed the contemner to complete
Shows the order,
my lord, page 14 is the operative part.
page,
14, 1-4.
we have passed an order.
We have submitted representation, but lordship.
The expectation that in case all the necessary documents are furnished. No. This does not entail a contempt petition.
My lord, thing is that, my lord, we have a lordship.
Because we were not sure this is an order which says that it doesn't mean that. Have you filed all the documents?
Yes,
All-
my lord, kindly see.
So therefore, that is a separate case. I mean, that they have not done it. We have passed an order. This is.
My lord,
this
thing
does
is that,
not
my lord,
call for a
lordship,
contempt.
kindly see for.
MS Sharma, please look into the
Lordship,
matter.
paragraph 7, kindly see for a moment. Once we submitted this, my lord, order before the contemner, he said that this kind of order coming regular, we don't have other job to do. And second thing is that, my lord, again, we
This
submitted.
communication, cannot be believed.
It's a clear-cut case of, my lord, defying the honorable court's order and disrespect to the, my lord, the order that has been passed by this honorable. Even, my lord, we have submitted
Take
reminders.
instructions in the matter.
Beg your lordship.
Take instructions in this matter.
I will.
Now that we are not entertaining the contempt application here for the reason of the last paragraph of the order, which does not, I mean, that's not in the nature of a mandamus. Correct. But the observations also are to be followed. Just check up and find out.
I will.
You're not aware of this, therefore,
My lord.
give a copy to her.
I will.
But
They are
yes,
only adjourning the matter.
he has shown, my lord, most disrespectful attitude.
Let copy the development as a report.
See, then we will say that let that disrespect be shown to us. We don't accept it.
My lord, he required to
That's
call
between,
personally, my lord.
between the
My lord,
proposed
thing is that, my
contemptor
lord,
and the
people are
court.
getting really very harassment. My lord, second time once he intended to submit reminder,
We-
he refused to accept.
You may not have come up with the necessary documents.
My lord,
we can't
everything
issue
I have
notice like
submitted,
this.
paragraphs, my lord.
Mr. Counsel, the way we have passed our orders, that does not call for a contempt petition if it is not done. We have said that we expect, we trust that it shall be done. That's their duty. It's
No.
plenary powers are theirs.
But-
There must be some reason, unless you say, find out and tell us.
My lord, my lord.
Let this matter come up for consideration on 10th of February,
My lord.
under the appropriate heading, under the same heading.
item 9 for admission.
Where is negotiation?
Faith is lordship. Huh? Oh, yeah.
Yes,
My lord,
any development?
yes,
in
my
it?
lord, I wanted instruction from my client. How much they can, my lord, the lordship will kindly have a look at it. I give it to you. my lord.
Have you given it to him?
No,
No. Then if you don't come up with an agreed amount, then we dismiss your appeal. We can't help it because it's logical. It is backed by law.
my lord, your lordship is right. But my lord, initially,
We try to mediate.
that's why my endeavor was, my lord, I tried to persuade my client.
Mr. Bhattacharjee, what do you
Yes.
say to the last?
My lord, as per your lordship order, they never approached us, but of our own, we have approached the DC to estimate the entire facts, my lord. And
No, we don't want facts. We want the price.
valuation of the land and all. Yes, yes. As per the, we have approached the DC for valuation of the proper rent as well as the compensation. Now, I have given that, my lord, your lordship will
Look
find.
at this.
So it has come out
Suppose-
46 lakhs. We are ready to compromise at 35 lakhs, my lord. His total come out 46 lakhs. The land value was given 28 lakhs, something.
Reduce something more.
Yes. 28 lakhs, 9.
Try and understand this.
Yes, ma'am.
Now, we are not supposed to do all this, but mediation for the nation, you have heard. So it is not a default option. We are trying to have it settled. Otherwise, you will get this money after your life.
But we have agreed to the party says
See,
35 lakhs.
these institutions are like leviathans.
Yes.
They'll sit over it, will
Yes.
file contempt.
Yes.
They'll again go before the Supreme Court.
And all this will go on, my lord.
So therefore, you settle for an amount, of course, not 15 lakhs.
Not, obviously, my lord, that is why I say.
But why do you, Mr. Roy Chaudhary, you should have sat across the table, no? You imagine the price on your own.
My lord, will kindly look at two documents I just.
We-
My lord, in fact, my lord, they want,
that case,
they
you
want-
are-
my
in
lord,
that case,
my
you
lord
are
is right.
different.
My lord is right, but on the last occasion, my learned friend himself wanted 15
No,
lakhs.
we are
No,
not.
no. I
We
didn't
are
say
not
Yes,
there.
he also indicated.
We are here to, we have been called upon to adjudicate.
That's it.
Now we have additionally taken this burden on ourselves for
That's why,
mediation.
my lord, in
So
order.
now, if you don't want to even sit across the table and talk, then.
I don't
let
mind,
you
my
argue.
lord, he can go and approach, my lord, that is
I
not.
was-
Now,
they have
who are
never-
you? The order is against you.
No, it's true, my lord.
Gone are the days when these organizations behave like, colossus.
No, the lordship is right. Lordship is right, my lord. That's why, my lord, I said I offered this. This is the amount I offered it to my.
Don't offer, sit across the table, go for negotiation. If not, argue on merits. If you're not interested, we are not.
I mean, I know, my lord, I understand, my lord, I understand.
We
That's
are
why, my lord.
giving one more opportunity, settle, or we decide on merits.
Yes, my lord. If he doesn't agree to the agreed amount, my lord, I mean, or the offer, that your lordship will have to.
Today he says no.
No, yes,
His
15
offer is
lakhs.
is 35. So you argue on merits, forget it. Up till now, you have taken this a stand as if
My
you
lord,
are.
this I didn't
See,
have, I can.
In these matters, you can't behave like a sovereign.
No, okay, this is not my money, my lord. After all, it's state's money. I cannot.
The land will 58 lakhs.
Oh, yeah, maximum, right? Okay. Anyway, you argue on merits. Will.
Then, my lordship has given me, I can send it to my client, and then ask my client to,
Because you-
this I didn't have, this I can.
Mr. Roy Chaudhary, you will not be obliging us. It is for you.
That's why I'm
Otherwise,
asking.
we say that we don't find any fault with the order. Go and settle it.
All right, my lord, lordship will adjourn the matter, then I'll ask for, to see this, and my lord, if they can sit together, my lord.
It appears that the parties have not sat across the table to negotiate the price. Unilaterally, the appellant FCI has offered a maximum of 50 lakhs for the plot of land in question. Whereas Mr. Roy Chaudhary, Leonard Counsel representing the respondent.
It's a PK Roy, bro, it's not K. I'm not sure.
PK Roy, here it is written PK Roy Chaudhary. You people don't write the name properly. Mr. PK Roy, Mr. Bhattacharjee, Leonard Counsel for the respondent number one, however, has submitted that a calculation was made on the basis of assessment of the price with necessary exemplars and a ballpark figure of around 35 lakhs has been arrived at, which for which price the respondent number one is ready to settle. Mr. PK Roy, senior advocate appearing for the appellant. हर जगह Mr. PK Roy कर देना. Roy Chaudhary यहाँ order में लिखा हुआ है. Submits that he shall communicate the aforementioned offer of respondent number one to the authorities, to the Ford Corporation of India for its final response. Thereafter, final response semicolon, whereafter this appeal shall be dealt with on the merits.
Yes.
Re-notify on and re-notify on, we are giving you 3 weeks. No further negotiations from our side. You will argue the case. He will argue this.
Yes, sir.
27 February,
27
March.
27 March, my lord.
Oblige your lordship.
He is telling you the date.
27 March.
27th of March.
Yes, oblige.
Oh, next to the.
Item 10,
Yes.
My lord, the issue before the largest signature was, my lord, whether the labor court, my lord, would allow the management to adduce fresh evidence for the first time when there was no departmental inquiry conducted by the management. The
Situation is the same when the inquiry is defective
yes, same.
or there is no inquiry.
Yes, that's right.
Right.
That is
So therefore, in this case, there is not a total no-no, despite, even in the constitution bench judgment.
yes. That's another constitutional side. The tribunal has the power, but when you will exercise the power?
That's right. That has been decided. Now, there was a dispute with respect to Goyal's case and Rajinder Jha's case.
As
Are you
that is
aware of the latest judgment on the issue?
Karnataka has decided.
No, that's in 2003.
Right, madam.
This is Uttar Pradesh State Transport Corporation versus Gajadhar Nath, 2022, 3 SCC 190. Just have a look at it. You don't have a case.
22 3 SCC, my lord.
2022, 3 SCC 190.
190. My lord, can I?
Uttar Pradesh State Transport Corporation versus Gajadhar Nath. Just
Well,
go through it and
lordship, that is better. my lord.
then argue.
That's
We
right.
give you 1 hour.
That's 1 hour. My lord,
Only.
let it be, my lord, Monday.
But why?
My lord,
It's a judgment which runs in about
okay, my lord. Okay.
25, 30 pages.
That's
Just
fine.
go through it. I don't want to take you by surprise.
No, no, no.
This is the
That's it.
judgment which we could lay our hands upon. See, what had happened was this. Now, there was some kind of difference of opinion between the judgments in Sambhu Goyal and Rajinder Jha. So therefore, 5 judges bench was constituted. After that judgment, in that judgment, there were concurring views, but the logic employed was different. There was one dissenting view which says that any time it could be filed for proper appreciation of facts. But there. in
Pleaded,
mo-
it has
in
to be
ma-
pleaded. That
in
is
ma-
what the Supreme
no,
Court.
in majority of the opinion, it was said that this is not a statutory rule, but this rule we are proposing only for the reason that it would serve the management and the employer both. Because otherwise, the employer can act, truant, and he would come up with witnesses at some stage, and by that time, the employee would be absolutely penniless. He would be in dire straits. Employer will not care for him. It was under these circumstances, but not always it has to be pleaded as an alternative plea. Now here there was no inquiry. Only 3 show cause notices and you were terminated. Correct? So thereafter, the time lag was only less. You were examined, cross-examined, you offered your affidavit of examination in chief, you were cross-examined, and your.
Then they want it. It is after that.
So it was immediately thereafter. Where is the statement? Where is that line in that constitution bench judgment which says that in all cases it cannot be allowed? Read the concurring judgment of Justice Patil.
I have read it below.
So
They say that the rule, the industrial tribunal rule provides the tribunal has the power, or labor court has the power. But when it will exercise the power? Well, it is not that the tribunal has exercised the power. It is a matter of routine. My evidence is cross-examination over, then said you
I'm
have.
reading. Therefore, you please read.
Well, I am not against their reducing evidence. I'm
Yes,
only
yes,
against.
that. We are giving you that judgment. Just
Lordship,
go
I'll go through it, madam. Let it come.
through it in detail and then come back to us.
Lordship.
I think the learned single judge has applied this logic, and he's correct. He says that had it been a defective inquiry or inquiry was found to be bad for some reason or the other, then perhaps as an alternative plea, this had to be done, and it had to be done in the
My lord, I just make one submission. My lord, if I would have known in their pleading or otherwise that they would adduce fresh evidence, I would have, my lord, reduced my evidence on that, knowing that, my lord. I am just taken by surprise now. I have adduced all my evidence, disclosed my case, and then they said I will reduce. How can it be, my lord? How can it be?
All right, you look at this then. Otherwise, this case would be.
No, I understand what the lordship is indicating, but my lord, my lordship will understand.
We have to balance it. How would an employer prove that you were there was some misconduct on your part?
No,
as
but
an editor, as a sub-editor.
That is why the rule says.
As a sub-editor of Assam Vani, you projected yourself as editor, and then you wrote articles in different papers. That was a serious misconduct for which you were noticed.
Prove it, my lord. They have not proved it. Adduce evidence. I don't object, but you bring evidences in the domestic
And
inquiry.
this has been continuing since 2006.
I cannot be faulted for this.
Please go through this judgment
Lordship,
and come back to us.
It's better.
Maybe on Monday only.
Lordship, Monday.
We will not delay it further.
It's better Monday. Monday. Monday, my lord.
As prayed for on. Have you taken the note of the judgment?
Yes, my lord.
Uttar Pradesh State Transport Corporation versus Gajadhar Nath. We would have disposed this off by virtue of this judgment, but then we did not want to take you by surprise, as you have been taken by surprise by your employer.
I'm for the employee.
Sorry. Therefore, you have been taken by surprise by your employer.
Lordship is right.
So we did not want to do the same thing to you.
Let me go through it now. On Monday, my lord.
As prayed for on behalf of the appellant, let this matter come up for consideration Monday.
2nd February. Item 11.
It was very.
Lordship, this similar to the disability pension.
Just a minute. Close it. अपना एविडेंस नहीं लाया Yes, yes.
Lordship, this disability pension matter, Lordship, that series matter, Lordship has already admitted. The other cases is fixed on 10th of March, Lordship. So same order maybe, and this matter may be taken up. Here he was discharged on 3 counts. 2 of the count we accepted and we gave him rounding out of 50% disability. The 3rd count has been allowed by the Armed Forces Cabinet. So it will come up along with that series, Lordship.
We have heard Mr. B. Chakravarti, learned as a night.
Lordship? Yeah, yeah, Lordship has also passed some order in that series.
Where is there our order?
Yes, slightly different because the DSC part was also there. Here he has not engaged in DSC part, Lordship. It will be similar to which I have furnished.
We have heard Mr. B. Chakravarti. Mr. B. Chakravarti, learned counsel for the petitioner / Union of India and others. The challenge in the present petition is to the order dated 3rd of April 2023 passed by the Armed Forces Tribunal, Regional Bench, Guwahati, whereby the application preferred by the respondent by OA number 18 of 2020 has been allowed, granting him disability pension for a 3rd disability, namely osteoarthritis in both knees. Which was deemed to be attributable to or aggravated by the military service of respondent number 1. The contention of Mr. Chakravarti is that such an order is legally flawed. It ignores established pension regulations and an incorrect appreciation of the law passed by the Supreme Court in which judgment Dharmveer.
Lordship, AFT relied on Dharmveer, Lordship.
Justice Mukhopadhyay's judgment.
Lordship. Our case is that, Lordship.
We have followed your case.
Lordship.
Or tell what happens. In Dharmveer Singh versus Union of India and others, bracket 2013, 7 SCC 316. He wants to stay, therefore something has to be written. You want a stay of the order, no?
Lordship.
So therefore you have to argue this.
Lordship.
The respondent, number 1, from an ex-army personnel, after having served for over 24 years, was discharged on 31st of January 2005. At the time of discharge, the release medical board assessed him in a low medical category due to 3 disabilities, one being osteoarthritis in both knees. The 2 other disabilities were found to be attributable to military service with a combined disability rating of 20%, qualifying him for war injury pension benefits. However, the third disability was rejected as it was neither found to be attributable to nor aggravated by the military service. Which decision was taken on the expert opinion of the Release Medical Board. The respondent number 1 had accepted such decision and had been receiving his pension, including the disability pension, for many years, when in 2018, he sought information through the RTI mechanism regarding his entitlement pursuant, semicolon, pursuant to which he preferred an application seeking disability pension in the year 2019 for the third condition, namely osteoarthritis. Such an application was rejected as being time barred. It appears that without losing heart, the respondent number 1 thereafter approached the tribunal, Armed Forces Tribunal, The tribunal, by the order impugned, next paragraph, the tribunal by the order impugned held that the osteoarthritis in both knees of the respondent number 1 was attributable to and aggravated by army service, entitling him to disability element in his pension for life, and made it effective from the date of his discharge. However, the arrears were limited to only 3 years before the filing of OA in the year 2017, with 8% interest if not paid within 4 months. The decision of the tribunal, Mr. Chakravarti has argued, is based solely on Dharamveer Singh Supra, where it has been held that there is a presumption that the disability arising during service is service related unless proven otherwise.
It's basically, Lordship, it's basically said at the time of entry, if it has not been depicted, then it is attributable. That is what there is.
Mr. Chakravarti, what does it mean? What we are dictating?
Not.
If he is in military service, if in the beginning it was not pointed out, then any disease is attributable to medical service. What else we are stating? You have not even argued this. We are putting it in your mouth. Unless proven otherwise. Mr. Chakravarti has submitted that there have been subsequent amendments to the entitlement rules. Stop even otherwise, the application of the decision in Dharmveer in the facts of the case of the respondent number 1 is incorrect. Stop. In Dharmveer, incorrect. Stop. The release medical board at the time of his discharge, had with reasons rejected osteoarthritis to be military related, to be service related or aggravated during service. Stop. Under such circumstances, after such long period of having accepted the discharge, the respondent number 1 was allowed the disability pension. Let notice the issue to respondent number 1 on steps being taken by the petitioner within a period of 2 weeks, both modes, returnable. Mark 10. Up till such time, the order passed by the Armed Forces Tribunal shall remain in abeyance. Hmm? Yeah. एक बार डिसाइड कर लो कुछ हिसाब से
27 more.
Safely obliged.
Item 12,
Take instructions, Ms. Sharma.
But I have certain instructions coming in from the ADC, who merely says that he's not authorized, only the deputy commissioner is authorized, because the power has not been delegated to him.
No, that we don't know. You applied before whom?
Yes, your lordship, we have applied before the deputy commissioners.
So deputy commissioner has to take that decision. What instruction have you received? Who has given you instruction, Ms. Soumitra?
My lord's
Soumitra.
ADM.
Soumitra or Sumitra?
Sumitra.
Sumitra.
Yes, my lord.
Who has given you
The
this?
ADC, my lord.
Who is he?
Assistant deputy commissioner, additional deputy.
No, he is absolutely ill-informed. Did you take?
I had written to both.
No, you take telephonic instruction. He is the person who has been addressed this.
Yes, I will.
District magistrate has to, you ask district magistrate.
I will.
Otherwise, we pass an order.
I will.
You're abdicating your functions. Please don't do that. You deny that necessary documents are not there. We can't take call. But beyond that, you can't know.
Yes.
We are restraining ourselves from passing an order because the Supreme Court has said that please don't. But then the provisions contained in the SARFAESI Act have to be followed.
Complied with.
They have no decision-making authority there.
Yes,
They can't adjudicate.
Minister.
They have a 14
9 points
checkpoint.
affidavit.
9 points or 14 points. Somebody said 26 points.
No.
It's the checklist.
Checklist.
Proviso.
Tick, and if any document is missing, ask for it. Otherwise, you proceed ahead.
But in my case, your lordship, order has been.
Be defeated. Tribunals are working day and night.
Yes, sir.
The loanies are being put to so much of difficulty. Courts are not entertaining their petition, saying that it's a specific court. Don't bother us. And you don't do your work.
I will. So
take instructions again. Otherwise, if you have to say anything in opposition, you file your affidavit.
I will.
Yeah. Ms. Sharma seek some more time to pass on these, seek some more time to take clear instructions from response number 2, 3, 5, and 6 regarding regarding no action having been taken under section 14 of the SARFAESI Act 2002 on the application filed by the petitioner. Re-notify on 3 weeks, 2 weeks.
12 March. Item 13,
Wrong forum, sir. Wrong forum.
Only 1 month time, may be allowed, if possible.
This is a
Shall
wrong
take up.
forum, sir. Wrong forum. You're barking up the wrong tree.
Knowing fully well, my lord.
So go before DRT or whichever forum. We'll not keep it pending. Don't ask us to dismiss it because we'll dismiss it on merits. After some arguments, Mr. Mr. A. Das Gupta, the senior advocate, seeks permission to withdraw this petition in order to agitate his claims before an appropriate forum, if so desired. Dismissed is withdrawn with the liberty of person.
item 14,
Open dumping you. Where is the photograph? Where are the photographs, Mr.?
Yes, madam, in the new. Yes. And arrest there with madam. And
Yeah, boundary wall. Look at this. Mr. Das, look at this. Look at this photograph.
But I also have the photograph, my lord. I can produce before your lordship, my lord.
Yeah, which photograph here? Now we'll appoint an advocate commissioner.
madam,
Go and see.
Why, my lord, may I just explain to your lordship, my lord? Their first prayer,
Tell us this. Is this a wrong photograph or a photograph of a wrong location? Say this, we will have the person who has shown the affidavit prosecuted.
lordship will also have a look of the.
You say that this is
Lord,
not.
I haven't received it, my lord, just now.
I have served my lord, served the copy to them. So all the copies served. my lord. In the office.
Just who has shown this affidavit?
My lord, there is Subrata Rai, myself.
You have shown the affidavit.
Yes, ma'am.
Why do you do this?
Our petitioner, the petitioner on.
Why do you
What
do
they are,
this?
my lord,
Suppose this turns out to be bad, we'll prosecute.
My lord, the pen drive I have given on the geotag pen drive I have also given along with.
Let's see your photograph.
Lord, they are praying to shift this.
We are not on that now. What is their
Lordship-
prayer, whether that prayer is feasible, whether
Fine.
you have earmarked 10 bighas, we are not on that.
Fine, my lord.
Now we
Lordship-
are on this.
Lordship is on the point that whether hygiene has been maintained or not.
No,
No.
you have said that it is completely boundary line.
Boundary wall is there, my lord. The entire plot has been boundary wall and construction is going on for installation of a solid waste management plan.
That all we have stated.
Yes, my lord. Lordship will see that concrete slab has been, they have taken picture of some places that suits them.
Mister, you should not have sworn affidavit yourself. You're a lawyer, please.
I have not affidavit by Subrata, my petitioner shown affidavit.
Your petitioner has.
Yes, ma'am.
He's not coming up correctly. We will ask somebody.
So, my lord,
गलत नहीं होगा, but does not give a correct picture.
my lord, we have filed an affidavit that is not.
Mr. Mahanta, can you please come up? Now, please bear with us. We are giving this task. We would have asked Mr. Das only to go there, but now he's representing the party. Therefore, we are asking you to make a visit. It shall. No. No, neither the state nor the petitioner will pay for it. I think you have to work for. Is it? It's very far off.
Hailakandi, my lord, about 318 kilometers from here.
I thought it is nearby. It is in Hailakandi. Anybody from that side?
My lord, I cannot be there, otherwise my incident I am to mention here, my lord, my nearby village, I remain there originally.
Lord, may I just explain one, Lordship will
Mr.
take a call.
Mandam, in any case, in that case, you shall be paid your to and fro expenses and everything by the state.
My lord.
You go to Silchar and then drive to Hailakandi and then come back. Anyway, we'll see. Please take.
Lordship will take a call with regard to Milord making an inquiry. But if your Lordships, I have filed an affidavit day before yesterday, that is not on record somehow.
You
Milord,
filed an affidavit?
Yes, my lord.
Why didn't you ask for it to be summoned in the morning? He had asked for it.
I understand, my lord, somehow skipped it. My lord, in my
The
affidavit, I
the
have
affidavit, anyway, let it remain. The affidavit filed on behalf of the state.
respondent number 6, my lord.
The affidavit filed on behalf of respondent number 6 is not on record. Let it be placed on record on the next date. Re-notify on 30. Huh? When?
My lord, any date convenient to you, lord.
We'll give it in.
Except Thursday.
In the week on 9 to 30, except Thursday.
Yes. 11th
11 fine.
February.
Fine, my lord.
Otherwise, my lord, as per the latest decision of the Honorable Supreme in MC Mehta's case, my lord, Honorable Justice.
My lord,
dispute
that
My lord,
may I just
open
explain
dumping,
one
even a
thing?
single day open dumping is not allowed by Honorable Supreme Court. They are continuing even the last day information. now.
Open dumping. my
Yeah,
lord.
exactly. The photograph says.
Kindly, kindly, yes, yes. My lord, we are
All right,
installing
all
a
right.
solid waste management plan slabs are there. 2 months left for completion of the
No,
project.
nothing is done. After filing this
Yes,
PIL, my lord, they have started.
Mr. Das, can you ask the DC or any other authority there to send us the drone photograph of that place?
Yes.
Yes. Yes. State is here, my lord. I can coordinate with the state council and I.
All right. Please send us that of the location.
Fine.
All right, yes.
Item 16 and 17.
May I please, Lordship? Lordship, we are filing our affidavit.
This is, I don't think you're a young council. Otherwise, it's a case where cost is required to be enforced. The administrative committee, the library committee has taken a decision. You want to tell us that the Guwahati Law Journal is bad? We are not doing it. It's our choice. Can a company force, can a publisher force any institution to buy their product? What rate? Why rate? There's no largesse, there's no, you have not set up your printing press at our instance, no? Have you? Do we owe any responsibility to keep you alive?
Your Lordship must senior.
Have you followed what we are saying? Normally, this does not fall for consideration in a petition under Article 226 of the Constitution. It is not something like public contract where the state is bound to treat all players equally. No. In fact, tell me, let me not speak. For all these months that I'm here, I have not seen any one of the journals except the Supreme Court journal. And even otherwise, the Supreme Court has come with neutral citation, and you're forcing, and can we do anything in the writ petition? Can it be adjudicated? Where is your senior?
He's on his way.
No, she cannot be your senior. She is just.
Take him on to sir.
Yes. Are you aware of the facts of this case?
I'm somewhat aware, Lordship. Lordship may kindly grant us some time. We are filing it today. Lordship may decide it on the next date.
No, it doesn't fall for our decision. That's the whole difficulty.
What Lordship is saying?
Who is the advocate who has filed it? I mean, I don't want to trouble you two young persons. You filed here, usko bulaiye. We will let you know. If he doesn't withdraw, we will impose cost. Na? Mr. Take him on.
I'll let him know, Lordship.
I don't think it is it's a dispute which can be adjudicated. There's no dispute.
First of all, what right of the petitioner has been violated, my lord?
Huh?
What right of the petitioner has been violated?
No, what?
My lord, it is a prerogative of the, my lord, buyer.
I don't look at it from that point of view. We say that can you force a customer?
Yes.
Can a
Cannot be.
company force a customer to buy his product?
My lord, that
Is it a contract which
My
the
lord.
state is giving to parties? Please. आपकी law journal hai, some other journal finds favor with the library committee and you say that no, previously library committee asked for 37
now why
copies,
not?
37 copies, today you issue a mandamus, please purchase. What like? Who should, I mean, withdraw this petition, take instructions from your senior and withdraw this petition. We don't want to say any further.
Lordship, I'll take it.
We will keep it on Monday. We will not keep it pending unnecessarily. It adds bad name to the institution, High Court, that such petitions are pending before this court for such a long time. We should have dismissed it today. But for the young faces of two advocates who appear to be very young at the bar.
Thank you for the.
And don't ask your senior to come. It will be an embarrassment. Take instructions, withdraw the petition. That's the best way to give a decent burial to such wrongly misconceived petitions.
It. Sunday.
Monday.
Monday, second. Item 18.
Order date.
Lordship, before Lordship goes into the brief of the matter, so on the previous occasion, we have been asked to take specific instruction as regards the amendment which has been brought in. So we are still waiting the instructions. So can it be posted next week? Wonderful.
Where is that notification?
Lordship, the writ petition, Lordship, page 31, Lordship, Annex of 4. By this amendment, Lordship, the scheme has been amended to provision. Amendment of para 22 is bill number 2. In the principal scheme, in para 22, for clause B and C, the following shall be substituted, namely, notwithstanding anything contained in this paragraph, an officer not below the rank of assistant provincial commissioner may, on the front, request in writing of any employee of a key state or a key factory to which this scheme applies, and his employer enroll such employee as a member or allow him to contribute more than 15,000 rupees for his pay per month if he is already a member of the fund, and thereupon such employee shall be entitled to the benefit and shall be subject to the condition of the fund, and employer shall pay the administrative charges payable and shall comply with all the statutory provisions in respect of such employee. See, every member employed as an employee of the tea state or tea factory to which this scheme applies shall contribute to the fund, and contribution shall also be payable to the fund in respect of him by the employer. Such contribution shall be in accordance with the rate specified in para 23A. And Lordship, this provided, Lordship, this part is affecting us, provided the subject to the provision contained in this clause be above where the monthly pay of such member exceeds rupees 15,000, the contribution payable in respect of by him by the employer shall be limited to the amount payable on a monthly pay of 15,000.
So you will pay only 12% of 15,000.
Yes.
Why? What is the purpose of contributory provident fund? Whatever is the salary of the employee, that's not your business. You will contribute only 1,800. Correct?
Above, yes.
Where, by what logic?
So-
What is the purpose of contributory provident fund?
On that specific points, Lordship wanted to have a clarification because already we have filed 2 affidavits. So this affidavits doesn't speak as regard the decision why it has been arrived at. So at least
No,
we-
it's very unreasonable. no?
that's true.
The purpose is defeated. In the first instance, you say that anybody can enroll. The person would enroll only for the purposes of getting the contribution from the employer,
Employer,
equal amount.
equal amount.
So how is it that you put a cap on your contribution and allow anybody to contribute whatever he wishes to? Now, what is this contributory provident fund? Which scheme? It's not a Ponzi scheme or something. It's a scheme by government.
No, previously the.
Find out and tell us.
Yes.
And come up with a proper logic which is understandable. Otherwise, we strike it down. Have you found any parallel in any other service with respect to the contribution? Nothing. Nowhere.
No.
So what the purpose, the logic of contributory provident fund is this, that he will also contribute, you also contribute.
Only the contribution percentage has been brought.
Quantum.
Quantum. But anyway.
Unless you would have said that whatever be your salary towards CPF, you will deposit only 1,800 rupees, we will deposit it. You permit him to deposit any amount. That also, I don't think it's correct. It rises with the rise in salary. It increases with the increase in salary. Find out and tell us.
Yes.
All the parallel. Take down. What is his name? Mr. S. Bodwal, learned advocate for the
State responsibility.
for the state. Seek some more time to address this court on the issue raised in this writ petition. The petitioner, next paragraph, the petitioner here is a registered trade union of Assam Tea Garden Workers who has challenged, which has challenged the notification issued on 12th of November 2024 by the government of Assam in its Labor Welfare Department, which essentially caps the employer's CAPS, caps the employer's provident fund contribution at rupees 15,000 per month, even if a worker earns more than that. So the contention of the petitioner is that such notification is illegal in view of the Assam Tea Plantations Provident Fund Act 1955. What have I said? Having been amended in December 2023 to completely remove any salary ceiling. Every worker no matter what his salary is, would now be entitled to PF contribution on full salary. This notification, this impugned notification, the impugned notification, it has been argued, brings back rupees 15,000 cap through a mere notification when the same has been removed from the parent act. This is precisely the reason why such notification has been prayed to be struck down as bad in the eyes of law. The affidavit, the matter shall be, ऐसे वो ये पहले ये लिख देना उसके बाद लिखो Mr. Barua, learned counsel for the state, seeks some more time to address this court on the issue.
Lordship, interim order passed earlier, maybe continued now.
These not, have we passed? We have passed the interim order. Interim order we have passed.
Lordship, 20, Lordship, last it was 20,
Interim order continued.
20 to 25 that's initially passed, Lordship. 20 to 25, it was initially passed, and last order also it was continued, Lordship.
Till further.
Lordship.
16-3.
Actually, this bench is not very inclined to
Lordship.
pay the notification or legislation. We decided.
Lordship.
That is very difficult, that the law says no.
Lordship. Last occasion, Lordship.
But then once it has been done, we will not
Lordship.
tinker with. Mr. Barua, get ready. I will. Okay.